His kid is so soft, bro. He's so soft.
Attend the court, please. The Honorable Supreme Court of the State of New Mexico.
Please be seated. Good afternoon, Council. We're here this afternoon on S-1-SC-38773 Wallbro versus Nolte. Can I have entries of appearance, please?
Diane Garrity and Rosario Vega Lynn on behalf of the two other petitioners. Thank you.
Paul Melendres and Linda Melendres on behalf of the respondent.
Thank you. All right, Ms. Garrity, it appears that you have reserved 24 minutes for your presentation in chief and 6 minutes for rebuttal. Is that correct?
That is correct.
All right, you may proceed.
Thank you. May it please the court. Good afternoon, Your Honors. Counsel. We're here as a matter of justice before this court. This family has had a long journey that has taken us to this spot. We have tried to seek the truth. We have tried to uncover the truth, and we have tried to seek justice in terms of some of the acts and omissions that failed to occur here from the Office of Medical Investigation. Today, we seek the following relief from the court. We ask that the district court's decision on the writ of mandamus to amend the death certificate from unknown from suicide be affirmed. We ask to modify the American rule for attorney's fees for an exception for work involving public policy, such as here, when a government agency must be compelled to carry out its mandated and ministerial functions. And last, we seek an order mandating OMI issue regulations for a family next of kin to request a post-death review. Death certificates are important vital records in our state. They're called vital records for a reason. We need to accurately reflect how someone dies in our state, because how someone dies and our death certificate information triggers all kinds of funding requests, public grant information, and ways that our state can initiate public health initiatives when certain health issues strike our state, or there's a trend in our health issues.
Ms. Garrity, I assume that you're making those representations as an effort to identify a matter of great public importance. But before you even get to that, I really need you to address standing. Standing is squarely before this court. You did not file a reply brief to address the arguments raised by Mr. Melendres. And so I think you need to start with standing as a preliminary matter to your presentation today.
Thank you, Your Honor. And we do have standing to proceed. We represent the next of kin in this case that has suffered an injury in terms of the accuracy of the death information the family received. There's also been mentioned in this case that only the Attorney General can bring a writ of mandamus against public officials such as OMI, and we believe that that's just not the case here.
What support do you have in the law that an individual family member's interest, I understand, let me be very clear, this is of great importance to a client. That is not in dispute here. But when it comes to standing against OMI, the law doesn't seem to support the idea that your client has standing.
Well, Your Honor,
Standing when it comes to death certificates is a government function, not an individual function. And the death certificate doesn't have anything to do with a quasi-property right in the remains.
well, Your Honor, respectfully, we disagree. We think that public and individuals should have standing to bring a writ of mandamus against a government agency when the government agency has failed to act. Here, it's been suggested that only the Attorney General can bring this case. And the Attorney General in this case has already declined to participate in full. We need to remember that Attorney General King, when he was in elected office, actually issued a letter recommending to OMI that that OMI amend the death certificate here because of all of the failings in the medico-legal investigation. And we believe that the Attorney General, on the same hand, declined to participate in this case. So if the Attorney General declines to participate as a litigant in a case, but the family is aggrieved, and the Attorney General agrees that the family is aggrieved, it seems that the injury should allow for the litigation.
What law do you have that you can cite to me that allows the Attorney General to pass off its obligation under the law in New Mexico to a private party? The state is the party beneficially interested in the death certificate, in the function of OMI. And so I need you to cite something to me that would support this proposition, because your papers are devoid of that support.
Well, Your Honor, we would suggest that, that the statute, the mandamus statute, allows for real parties in interest who have been injured by the government's failure to act in this case would have standing. And I would quote that, I would cite ACLU of New Mexico versus City of Albuquerque, that also quoted in re the adoption of WCK, which was a Pennsylvania case.
How do you address State ex rel Naramore or Cole versus Johnson, which are very clear indications that family members are not the interested party in this context? And then what do you propose that this court do with those pronouncements of the law in writing an opinion here?
We think that those cases are distinguishable. Naramone involved the writ of mandamus against the state district court judge, as well as a district attorney, to compel them to actually bring murder charges against the defendant. And I think that while the Naramore court stated that the family, the injured family, the murder victims, clearly had some kind of interest, it's really the Attorney General that has to bring those kinds of cases. And you could see that because the Attorney General would be the state official who could, in many ways, order the district court or have standing to represent district court judges. So
what about Paul? The fact that a case involves a duty that state officials owe to the general public as a whole is not sufficient to show that the case involves an issue of great public importance.
Well, Your Honor, I mean, that would ignore all of the other cases where not-for-profits and other interested individuals have brought writs of mandamus in our case, where the Attorney General has not been involved, such as Adobe Whitewater, the Secretary of State cases during the voting, related to voting during the pandemic.
How is this of great public importance then?
This is of great public importance because citizens who have loved ones who died don't have any kind of right to have a death investigation reviewed.
Why can't it be reviewed through a Rule 75 appeal?
Because there was no underlying administrative action here.
So
Rule 75.
So you're asserting that OMI is not administrative in any nature?
I'm asserting that OMI under state law has to have an inquest process. And because OMI fails to have any kind of regulations related to an inquest process or any kind of post-death review, that fails under due process.
So you want us to create an inquest process that will require essentially any and every death certificate in the state of New Mexico to go through court proceedings. I mean, I think that's the ultimate outcome of the relief you request.
Not necessarily, Your Honor. I think that goes too far. I think
it would be available to anybody who wants it.
Well, they could be limited by regulation from OMI. If they could exempt criminal proceedings, they could exempt certain kinds of deaths. But to just say that there's no right at all.
But if you assert that this is a fundamental right, which you do in your papers,
yes,
then that would be an equal protection problem to exempt certain categories of decedent from an inquest proceeding.
Well, Your Honor, that the regulation could be challenged on that. But what I'm suggesting is that basic due process, basic procedural due process here is triggered, that there are quasi due process rights for, in the dead body for people who die. You're just not allowed to, make up anything or make up any kind of decision. For example, the Cordia cases. Are you asserting
that Dr. Zumwalt just made this up? Is that the position you're taking?
No, it's not the position I'm taking, but the position we're taking is that the Office of Medical Investigation failed to follow vast majority of its medical legal investigation process, including any kind of analysis of state of mind, which is required in suicide.
It's required in suicide where it is related to insurance and wrongful death. Every single case cited by the district court related to state of mind is in the civil context, it's not in the medical context. So what can you cite to me that is legal authority that state of mind is required for an Office of Medical Investigator?
I believe it's in the medical legal investigation manual itself from OMI that there has to be an examination of intent. They have a
And
regulatory.
doesn't Dr. Zumwalt provide that in his testimony that is quoted in the district court's findings and conclusions?
Dr. Zumwalt was unable to identify, my recollection of Dr. Zumwalt's testimony was that he was unable to identify any information related to intent. The evidence produced at the district court related to intent was from the independent investigation the family undertook, and the documents and information that they were able to gather. That's how we were able to prove the omission, that nothing was reviewed. There was nothing about what the decedent was doing before the suicide. There was no analysis of bank records. There was no analysis of the fact that she was otherwise leading a normal life, that she had planned to travel for Thanksgiving, that she had had just recently returned from a vacation in Las Vegas, to buy work clothes.
Can't
That
people engage in all kinds of normal life activities and nonetheless take their life?
Yes, absolutely, Your Honor. And there could have been a suicide here. We're not denying that. What we're saying is that in order to reach a proper conclusion and a proper decision on manner of death, that's supposed to be based in evidence under statute, that under that standard, that OMI fell woefully short. The ministerial action is the medical legal investigation. There are certain procedures that have to be prescribed and undertaken here.
It seems to me that the trial court below really focused on APD's conduct here as the failure. APD's conduct, the number of people that were at the crime scene, the missing laptop. And so assume with me, and that's really what the trial court focused on here. It talks about the laptop extensively. So even if the laptop said, "Dear diary, I am a very happy person," would that force, as a matter of law, the OMI to reach a different conclusion?
I think what that information has to be part of the totality of circumstances that the medical legal investigation gathers up, so that the investigators from OMI can use the scientific method to prove the theory.
But what if that evidence doesn't exist? There's a presupposition in the district court's findings and conclusions that there would be something in the laptop to indicate that it was not suicide, and ergo that absence of presumed information, no evidence to support that at all, would disavow suicide. That's what the trial court hung his hat on here. And that, you can't say, well, maybe there's something that might exist, and therefore OMI has breached its duty.
Well, Your Honor,
That isn't mandamus.
Your Honor, the medical legal it's mandamus because the medical legal investigation is part of the process that OMI says that it undertakes. And the cause and manner of death decision has to be subject to evidentiary standards. And you get to evidentiary standards by following the process in the medical legal investigation. In answer to the laptop question, the importance of the laptop was multifold. One, it's an example of how the death scene was basically a free-for-all, as you know from the record. Pandemonium was how it was described. And it was also testimony from our experts in the case that often a laptop or electronic communication in the world we live in will often hold clues to the state of mind of the decedent. So maybe it's there, maybe it's not there, But when you take it into the totality of all of the omissions, all of the failures here, we think that there is only one conclusion, that OMI failed to do its mandated duty.
Isn't it really that APD failed to do its duties?
OMI is in charge of the body and the surrounding area of the body.
But APD had already done what it was going to do, whatever it is, because we're not here to try and sort that one out. But they'd already, so if hypothetically speaking, APD took the laptop and put it in the landfill, OMI can't control that. OMI only has the amount of evidence available to it. And from that, has to engage in reaching conclusions based on the evidence before it. And Dr. Zumwalt here, upon second review, reaches the conclusion based on the facts that were available that this was suicide. Carbon monoxide in the blood, not conclusive, but certainly an indication. Carbon monoxide pouring out of the garage when the first officers responded to the scene, the body in the car. All of those things are evidence that can lead to this result, might not lead to the result, but because it's an opinion that can go either way, and the experts here talk about how close a call it is, it's by definition not mandamus.
Your Honor,
If they had done something different with the conclusion that it was carbon monoxide, certainly. But not the suicide.
mandamus requires, the mandamus that we seek is requiring OMI because it failed to meet the legal standards by not conducting the kind of investigation it was required to under law, by not really failing to do that for whatever reason. You can't just blame another party and ignore your responsibilities. The OMI field investigator could have tried to clear the garage, could have tried to clear the house. The fact that the death scene.
What if they tried and failed?
Well, OMI didn't present any evidence of that.
What if they tried and failed? I mean, there were like 60 cops on the scene? Probably a little hard to try. But what if they tried and failed? Would it still be mandamus?
Yes, because there's a legal duty from OMI. If OMI had followed its rules and regulations, of course we wouldn't have mandamus. But OMI failed to follow its statutory construct. The OMI is set up to issue cause and manner of death decisions. They are required under law to execute a death certificate.
Let me ask as to that, because let's assume standing, let's assume some of the prerequisites for mandamus is, again, that's what we're talking about, whether it's a ministerial act or a discretionary act. And so essentially you're saying because they didn't follow their protocols, because the scene was potentially corrupted, that the only act that they could have is just to make a determination of undetermined because of the information that they had. And so why would we need a forensic pathologist that does the autopsy if that was the only conclusion? And the reason I'm saying that is, how is it not their medical conclusion, whether we agree with it or not? It's their medical opinion based on their training and experience in a discretionary act. Why is that their opinion, not a discretionary act?
It's not a discretionary act because when you look at what is considered a ministerial duty, the government actor is required to follow the regulations and the prescriptions laid out for them. So when the field investigator is not a medical
And I
doctor.
apologize. So their regulations and prescriptions, they got to determine within a certain period of time, manner of death, cause of death. They did that.
Correct, and they made the wrong conclusion because they didn't follow their policies and procedures.
So as to their policies and procedures so the state registrar, and so the vital statistics and state registrar are part of this case, but there are duties and regulations, and the state registrar is responsible for creating that mechanism that you're asking for. And under regulation 7.2.224, it does provide at least court orders received by the Bureau which order the amendment or creation of a vital record which are inconsistent with the information known or maintained by the Bureau may require a formal or other challenge. So it at least gave another mechanism or something to seek review rather than mandamus through their regulations.
Well, there was just simply mandamus. We filed the mandamus to compel OMI to do what it otherwise refused to do and otherwise really refused to review in any kind of formal way. The testimony at the district court was that there was no formal process in place. And so what you had to do was sometimes you have to call up and make a phone call to Dr. Nolte or whoever's in charge, and they might review your information or they might not. What we're seeking is something more uniform than that. That will lead to arbitrary and capricious results. And we think that, people who want to challenge, why their loved one died or don't believe that OMI, follow the right kinds of rules to make that decision, then it's, there's really nothing available for them. So the mandamus was filed to force a review of what actually happened here, to have an evidentiary hearing as is allowed under mandamus. You're allowed to have a civil trial. And then from that civil trial to reach a conclusion about whether or not those duties were actually followed. So it's really, our case is really not complicated. It's kind of simple. We think that the medical legal investigation constitutes the ministerial acts that are required here in order to have a manner of death decision that is reliable. I mean, we have a hearsay exception for death certificates. The information has to be reliable.
Is the chief medical officer at OMI an administrative officer of the state?
I don't know, Your Honor. I think that administrative officer of the state would be somebody like the Attorney General, who has more plenary authority.
Is OMI an agency?
Yes,
Okay,
of course.
I'm still going to go back to it's a Rule 75 appeal.
Well, Your Honor, I would just adamantly disagree with that because again, there's no underlying administrative record from which to appeal here.
The rule governs writs of certiorari to administrative officers pursuant to the New Mexico Constitution. That's Rule 75.
Yes.
You can disagree with me. I'm just pointing out the language in Rule 75.
And Rule 75H does require an administrative record, and there was just simply no administrative record here. There was no testimony developed at all. And so we're seeking to have OMI ordered to have some process so there's uniformity, so that, there are some families who have had death certificates amended and other families who have not. Well, what's the difference? Why do some families get relief and other families do not?
Well, and again, I'm sorry.
Go ahead.
Again, the regulations point, they have certain biographical information can be amended if at the time after an autopsy. And so they provide regulations and mechanisms for doing that. And then also the statute gives an intent that they don't want, because this is a state vital statistic, they don't want everybody that may be affected or disagree with the determination necessarily seeking an amendment. They want to rely on the Office of the Medical Examiner. And so my question that kind of relates to standing is the true injury. And I say that with all sympathy. I understand the family disagreeing vehemently with the determination of suicide.
My time is almost up, if I may answer.
Absolutely.
Is that there is injury, in fact, to families. Not knowing how your loved one dies or having to be subjected to the kind of action here, that clearly causes an injury. And I think that there's an injury to the greater public too, and why this court granted this case, because we need uniformity in decisions. We need to know that OMI is actually doing what they've been asked to do and what they've said themselves through their own medical legal process what to do. And we believe that the quasi due process interests in cases that we cited, do show injury in fact to families. And my time is up, so.
Don't walk away,
I did
man.
have-
Okay. there's
But
some
my
more
fire squad's
questions.
not.
the way I view the district court's findings and conclusions perhaps differs a little bit from Chief Justice Bacon's. The way I read it is that the OMI, in making a manner of death determination, is required to rely upon the investigation that's conducted at the scene, that their own regulations require that, and that's a ministerial duty. It's not discretionary that they can ignore the evidence at the scene. It's ministerial. And that in this case, that ministerial duty was not performed because of two things. One, the evidence at the scene was so compromised by what happened that evening that it's impossible to put that evidence to consider what it might have been one way or the other, or inconclusive, or whatever it was. And secondly, the OMI, as I understand the district court's findings and conclusions, failed to take that into consideration in making its determination that suicide was the manner of death. Am I missing something? And I'm not getting into that they had a ministerial duty to do X and Y, but because of what happened at the scene, it's impossible to have an accurate scene. But in any event, whether it was good or bad or indifferent, the OMI failed to take that, or Dr. Zumwalt failed to take those facts or lack of facts, or the disarray of the scene, and the things that were done and things that were not done into account in making his determination of suicide. And therefore, you're contending, as I understand it, that a writ of mandamus is appropriate because the OMI failed in those ministerial duties.
That's correct. And it's really as simple as that, Your Honor. It's not a complicated, fancy case that way. It's that the ministerial duties are outlined and they failed to happen for whatever reason. They failed to do that. And because of that, this decision is not reliable.
And that the experts testified that because of the disarray, the bad investigation, the disarray, loss of evidence taken away, and so on and so forth, that it's impossible to make an accurate determination. And that the only thing that's left available in non-discretionary fashion is undetermined or undeterminable.
That's the only conclusion that you can reach at this point in our minds. And that's why death certificates are allowed to be amended. You can have information that comes in afterwards. We just saw that in the Colorado situation where the young man died at the hands of police. There was a death certificate, an amended death certificate, when the investigation went a little bit further to clarify the manner of death in that case. And we think that there should be something. In this case, we have shown that the medical legal investigation procedures were not followed. It's OMI's job to follow those legal procedures.
Well, it's OMI's job to consider what the evidence was or wasn't.
Correct.
And as I understand it, from the district court's perspective, the OMI did not do that.
That's right.
Okay, thank you.
Thank you, Your Honors.
Thank you. Mr. Melendres.
Chief Justice, Justices, may it please the court. This case represents an important public policy question. The question here is, does this court allow New Mexico to revert back 50 years to the old coroner system by allowing individuals to challenge the medical determinations of pathologists in never-ending trials on cause and manner of death? Our legislature was clear when it created a mechanism for medical investigations in Statute 24-1-11. Our legislature modernized our system so that only highly trained medical professionals in pathology and forensic medicine would be making determinations on manner and cause of death, instead of relying on an outdated and often inaccurate coroner system because it best serves the interests of our state.
Are there any standards in place by which they make these determinations? Are there any standards?
The standards are highly trained medical professionals who use their education, their knowledge, their training to reach conclusions, opinions on manner of death.
So let's assume so you're saying there are no regulations, no standards to govern how they come about making the determination.
Just as though if you would go to a doctor at a hospital, there's no,
My question is very simple. There's no standards by regulation or otherwise governing how or what procedures are to follow in making the determination.
It is a medical decision, so no.
Okay. So let's assume for a moment, in the facts of this case, that Dr. Zumwalt said the manner of death was getting run over by a car in the light of all this evidence. That's his medical opinion. Same result? No remedy?
That's his opinion. And if you look to the death certificate, when you look to the death certificate, and I think that's very important, it specifically says, and this is a certified, remember, this isn't just a document. It has to be signed by a pathologist. And he must certify on the basis of examination and or investigation, in my opinion, the death occurred at the time, date, and place due to the cause and manner stated. So you, as a judge, may say, well, that's wrong. But it would be no different than the case in Narramore, where a district attorney decides not to prosecute a case. You may say he messed up, but that's his opinion, and it was a discretionary act. What I would tell you is our pathologists care greatly about their jobs.
Nobody's disputing that. My question is, and I think you've answered it, that you're saying their discretion is the only standard.
Their discretion, well, there is a process. First of all, Dr. Wright is the one who originally signed the death certificate and performed the autopsy. And then it went up, and you're able to escalate it to Dr. Zumwalt, who reviewed it twice. And he met with the information from the Attorney General. The Office of the Medical Investigator, we investigate. That's what we do to try to assist the judicial process. We are always open to new information. But I think as Chief Justice pointed out, there's no standing here because this isn't even a person. It is an estate. An estate has no feelings. This estate has not been damaged in any way. This estate has not lost anything. By definition, it has no legal remedy. It has no legal remedy.
Are you saying there's no legal remedy? So the example that Justice Vigil used, that it's flatly wrong, or are you just saying mandamus is not the remedy?
Well, mandamus doesn't exist, but I want to talk about your question. And I think you can actually find the answer to your question in petitioner's own expert testimony. And the Court of Appeals cited to Dr. Williams. And he specifically said that he would refuse a judicial directive to change the manner of death determination if it was inconsistent with his opinion because of his own medical ethics. Remember what you're being asked to do here. You're not just being asked to submit a new document. You are directing Dr. Wright to change his opinion to undetermined. As a medical professional, I'm an attorney. I issue opinions. You don't have to like my opinion, but the reality is it is my opinion based on my legal training, my review of the facts, my review of the evidence. Another lawyer may disagree, but remember,
let me follow up with you on that. So what if instead of directing OMI to change it, it was directed vital statistics, state registrar under the regulation I cited previously, it needs to be changed. There was a Rule 75, there was insufficient evidence or is arbitrary and capricious. Vital statistics change or amend that document. Is that possible?
I don't think so. I really recommend that everyone go to the volume, record proper, page 21, and look at that death certificate. And let me tell you this, as we said, even the petitioner's own expert said it wasn't unreasonable to consider suicide. It was not an unreasonable conclusion. This opinion is based upon a reasonable degree of medical probability.
Other than carbon monoxide, what points to suicide?
The decedent's toxicology results showed that she had a fatal level of carbon monoxide, Ambien in her system.
Other than carbon monoxide?
Ambien, alcohol, hydrocodone were in her system. There was no signs of trauma to the decedent's body. Decedent had a history of chronic depression. Decedent had recently undergone a traumatic event, the recent breakup of her law partnership. So there was a lot of reasons. And I would point this out to the court because I know you know this. We don't always, and I shouldn't say we, but OMI doesn't just always come upon a body. Sometimes it's a year later, and they're still required to try to make a determination. So these guys are amazing at what they do. And I tell you this, they will always tell you, nothing is perfect, but our decision is based upon a reasonable degree of medical probability, meaning more than 51%. So to file a writ of mandamus, to direct them to change their opinion, would potentially breach their own medical ethics.
So are you saying that there could never, that a determination as to manner of death could never form a basis for judicial review under either mandamus or Rule 75?
No, but I'll tell you how it works. If there's a life insurance issue, for example, and there's suicide, there is judicial review, and you will put up your own experts. You may call someone from OMI, and you can challenge it in that proceeding. But no individual has an interest in this. The only interest, as has been pointed out, is the state who declined. So we know mandamus is out. But let's talk about Rule 75. It's not an administrative process to reach an opinion as a pathologist. A pathologist is not like us, where we look at the rules and we say, okay, what about this? They are using their medical training in the form of an autopsy. A lot of times they want the toxicology results. Sometimes they make decisions based on the situation of the time of the person standing. The reality is it's not an administrative process. It's simply an opinion. It is just an opinion of a pathologist. That's all this is. And no one has a constitutional right to an opinion of the pathologist. Now, I will also note this. The Bureau of Vital Statistics understands that it is to a reasonable degree of medical probability. And so they accept the fact that maybe these aren't always perfect. They're willing to take those. One of the things we do know is, and if you read the record below, undetermined is the worst decision that you can make. We want to try to have some type of conclusion because, as Petitioner's Counsel noted, that's how our funding is based. Suicide, we are one of the highest rate states for suicides. So our pathologists always are attempting to come to a conclusion. And as Dr. Zumwalt said on the stand, this is my opinion. You don't have to agree with it. You can tell everybody I'm wrong, but it's my opinion as a trained pathologist and a record review.
And doesn't Dr. Williams, I think I'm looking at Dr. Williams' testimony. Dr. Williams also predicates his testimony on his own opinion.
Every one of the experts, and I always like to use other people's experts, especially petitioners, they all agreed in reaching this, it's a discretionary act. It's based on your medical training, and all of them implied they would not like the idea of a judge telling them to change their opinion. But when you go to mandamus, and that's what we're really here on.
Can I talk to you about standing?
Okay.
There's some, I don't know quite how to couch it, so I'll try and just ask the question directly. Why isn't there standing here? Because it's important to the public as a whole to have accurate records.
Because it's the estate. The estate is the one who is pursuing this. The Attorney General's office didn't. And so what I will tell you this.
Why can't the estate stand in the shoes of all New Mexicans seeking quote unquote accurate records?
Well, that's not the function to allow individuals to steal, in essence, or usurp the province of the state. It is the Attorney General's responsibility, and they chose not to do so. And it's no different than Narramore. So why not allow the state to, in essence, usurp the right of a district attorney and say, I'm filing a writ of mandamus and you're going to prosecute it? Why is it?
Could the petitioners here, I'm now getting a little far afield, could the petitioners here, upon disagreement with the Attorney General, filed a writ against the Attorney General? Or would that also be opinion-based?
That's what I was going to tell you. That's exactly it. What is when the Attorney General issues an opinion on the Open Meetings Act? He does it based on his training, knowledge, and he issues the opinion. And that's all it is, an opinion. And as we all know, as this court has said, it's not binding. It's an opinion. But so you're now trying to file a writ to tell the Attorney General to change his opinion about whether to intercede. I mean, that's why mandamus is such an extreme remedy.
Would mandamus lie in that instance if the Attorney General said, we're just not even going to answer the question? If they completely punt?
That's a decision. I mean, if you do this, you're opening a can of worms because you're going to give individuals the opportunity at every chance, whenever there's a discretionary act, to say, I don't like that, or you didn't make the right decision, and they're going to try to intercede with a writ of mandamus. I mean, that's why this is such an extreme remedy.
So if the Attorney General refuses to act, in certain situations, a private citizen can stand in the shoes of the Attorney General pursuant to statute, qui tam actions is what I'm thinking of. Does that have any applicability here?
They've done a key tam action to step in the shoes of the, I would have to study the
If
law.
the Attorney General, as I understand it, if the Attorney General, I never did a qui tam act, but as I understand it, if the Attorney General refuses to act in certain situations, that authorizes a private citizen to stand in the shoes of the Attorney General.
When I think of a key tam action, I mean, yes, under very rare circumstances, that may be feasible. And then you're going to direct, well, let's play this out. You'll direct the Attorney General to intercede in this case. So and I will agree, the Attorney General will have standing because of the vital statistics. So you now get to standing. But here's where you run into a problem, and this is why it would still fail, is because it is an opinion of a pathologist, which is discretionary as to manner of death. So you can link yourself in, except to the point that at the end of the day, this is a discretionary act. And as the Court of Appeals noted, I mean, all of the experts agree it's a discretionary act, and so did the Court of Appeals. Justice?
So essentially what you're saying, a private person would never have standing to seek judicial review of the OMI determination of manner of death under mandamus or Rule 75?
That's what I'm saying. And the reason being is you're going to have trial after trial disputing this. And all this is, it's just an opinion that goes to vital records. I'll play it out a little bit because I kind of like this.
Let me stop you. So then what? If they have no right of appeal through mandamus, they have simply no right to have something reviewed. Is that what you're saying?
You can, in the OMI process, you have the initial Dr. Wright who performed it. They then have Dr.
You can call
Zumwalt.
his or her boss, and that's it. That's all you can do, right?
And that's what our legislature intended. And what I would tell you is this: if people take issue with this, you can go to the legislature and amend the statute.
Well, isn't that not the case? I mean, they provided the state registrar could create what's asked for, some type of review process. So the legislature has provided that. And there is, I guess, what I'll call a catch-all, and that's that 7.2.224 court orders. And it provides essentially if the court orders some type of change, the agency needs to have notice that comes under vital statistics. So in this case, OMI, and a fair opportunity to contest that court order. And if they don't, the state registrar needs to change that vital statistic.
So to that extent, there is a process. But what we're here discussing is a pathologist's determination of manner of death, which is an opinion. So there are processes, and I have all the things that you're required to do, but in the end of the day, that opinion is based upon medical training. No different than if you go to a doctor at a hospital and they try to reach a diagnosis.
And it's also based on a review of facts, right?
It's a review on the totality.
Totality, and if the facts are so corrupted, is it a valid decision?
If the pathologist, based on their medical training, come to a conclusion of reasonable probability, it is appropriate. And what I would say is this: I understand where the district court took issue with what APD did. But again, OMI finds bodies 3 years later. There is no scene, and they're still required to try to come to determination. And in this case, our investigator took photos, secured the body, and all of the items next to the body as he was required to do. But what was most telling for the pathologist, as you heard from Dr. Zumwalt, and if you read Dr. Wright's deposition, is the fact of the toxicology reports, as well as to the state of the mind of the decedent.
So the lack of remedy, so to speak here, is limited to this context. Because clearly, our case law bears out that if there is a different kind of legal proceeding where the manner of death is at an issue in terms of other remedies, it's challengeable in that context, but that doesn't result in a change of the death certificate. So an insurance case, life insurance, the life insurance company asserts it was suicide. The beneficiaries have a clear interest in whatever that result is. The beneficiaries challenge that in the civil proceeding over what the coverage is in the life insurance policy. A jury determines, well, we don't think it was suicide. That still doesn't result in a change to the death certificate. Is that correct?
That's correct. And I kind of go back to the first question you asked about standing. No individual has an interest in the determination of manner of death. No one has a constitutional right to a pathologist's opinion. Again, in order to get remedies, you need damages. And that's one of the things that has never been discussed is how has the estate been damaged? And that's who's before you, an estate. An estate does not have feelings. An estate is simply there to distribute assets. The estate has no damages.
And this has had no impact on distribution of assets, as I understand it.
When asked by the district court what the damages were, there was no articulation of any damages that the estate has. And that's kind of the end of it. And I do think this is important because OMI has limited resources. And so to be consistently defending its opinions on manner of death that is simply a document that's submitted to vital statistics would have grave public policy concerns.
What about the public policy concern raised by petitioners here that we rely on the statistics generated by vital statistics for all kinds of grant funding, for example? Does that elevate this to provide standing to the estate, or does it make this a matter of great public importance, which are two different things?
It certainly doesn't give the estate standing. The estate, why would an estate, which is a legal concept, have any interest in vital statistics? It's an estate. So that's the first part. The second part of great public importance, vital statistics recognizes, and this is one of the things I think we need to emphasize, nobody is saying anything to 100%. It's to a reasonable degree of medical probability. And vital statistics recognizes that, accepts that, and in what it does want is to get these documents for the totality of the funding and different things. So the pathologists are using their medical judgment to reach an opinion. And that's all this is, an opinion. Now, what was ministerial, and this is, I'll give you the example of where mandamus would have been appropriate, is if we had not filled out the death certificate. And this kind of takes me back to King. I believe it's King where you have the land commissioner. And there, this court said, well, once you use your discretion to sell land, you must then do the ministerial acts of how you go about selling it. But it was discretionary of how to sell the land, or if to sell the land. And that's this case. It is a discretionary act to come to a medical opinion on manner of death. And then, of course, you must fill out the death certificate and do all the ministerial things by signing your name.
Let me ask as to that injury or damage, because we started out with In re Johnson from the Supreme Court case, and then also Barella, and that comes from Barella v. Hubble. And in paragraph 7, they said the prevailing rule is there's a quasi-property right in a dead body vesting in the nearest relatives of the deceased, arising out of the duty to bury their dead and the right to maintain an action to recover damage for an outrage, indignity, or injury to the body. So is it conceivable under our case law, this is an outrage or an indignity in characterizing this as a suicide? You don't have to agree with that, but
No, I'll tell you, and I'll go to Barella. I mean, it's the right to the custody of the body that occurred in this case. The right to have the body in the condition in which it was left dead without mutilation, that occurred in this case. The right to have the body treated with decent respect and indignity, that's there. The right to bury. Those are the quasi-property rights in a body. There is no quasi-property right to an opinion. And whether it's an outrage, I would strongly have to disagree with that, because suicide occurs, and what we want to do is try to prevent that. And so to say by coming to that conclusion, we somehow, I would stop there. I'm gonna tell you, I just couldn't agree with that.
So following up on that question, so was this body treated with dignity and respect when 60 people walk by and look at the scene?
As to OMI,
And it was, I give you, it wasn't OMI who had control of the crime scene, it was somebody else. But you're relying on their investigation, aren't you?
now, we're relying on a totality of the facts, and mainly, as you read,
And
the
that
toxicology
includes their
reports.
investigation, right?
I'm sorry?
What you're relying on includes the APD's investigation, right?
It includes the totality. It would be inappropriate not to take every evidence and fact you have into your determination.
That's the argument, is that they didn't. That in making a determination of manner of death as suicide, that the OMI did not take into account all of the circumstances, which included destruction of evidence, removal of evidence, people traipsing through the evidence scene. That's the argument, as I understand it.
And that is definitely their argument. And what I would tell you is, these are forensic medical
Does a
professionals.
forensic medical opinion have a right to not consider these facts?
Absolutely. Just as I, as an attorney, have the right to discount evidence or points toward my opinion. And what they did rely on, and they will tell
If
you.
you're required to do that. You're required to do that, is the argument. And the argument is they did not.
They are required to examine information to come to an opinion. That's what they're required to do. They're medical
They can
professionals.
pick whatever information they want.
They're medical professionals who are trained.
My question is, can they pick whatever evidence they want?
I'm not a doctor, but I'm going to tell you, my assumption they would tell you is we look at all of the information that is most likely to come to a conclusion. And the toxicology reports is what truly led these individuals to reach this
And there's
conclusion.
expert testimony in this case that they could not conclude suicide based upon all the evidence that was disturbed and taken away.
Dr. Spitz, who's their expert, testified that a finding of suicide was not unreasonable. Their own experts testified it was not unreasonable.
Does competing experts relegate things to mandamus? We have competing expert testimony all of the time. Does that render one expert subject to mandamus?
Mandamus is fundamentally flawed in this situation. I think what we're talking about are some greater issues, but the mechanism that they brought to bring this case, they don't have standing, and everyone agrees it's a discretionary act. So for that purposes, mandamus was not appropriate. I do think it's important to talk about some of these other general public policies because it's a nice opportunity to be here to speak to you all. But from the very beginning, this case should never proceeded. Mandamus was fundamentally flawed because only the state had standing. They didn't take it. And then, as we all know, the death certificate fundamentally says this is an opinion. It's a discretionary act. And Narramore conclusively would establish it. I think you were dealing with two professionals, doctors and lawyers, who are reaching their own opinions. And so that's where I see the case.
You told me a minute ago that nobody has standing to bring a review of these determinations. I mean, not the estate, not private individuals, nobody. Could there ever exist such an abrogation of the duties on the part of OMI that, you're telling me there's no judicial review, there's no administrative under 75. What's the result?
So I guess we can take a hypothetical and look at it this way. So if you have a pathologist who is a medical professional and decides not to perform an autopsy, not to do certain things, first there is a board that oversees OMI. They could internally direct the person to do that. You could report them to the medical profession. They're licensed. There's an avenue through that. But what we're saying here is that these medical professionals perform autopsies all the time, come to these conclusions, and it's to a reasonable degree of medical certainty. And so that's why when we take the example, and I know Justice Vigil says, well, APD walked all over the place. Well, what they're saying is at this decision is that it's more likely than not that it was suicide. I don't think they discounted the fact that APD was there and did whatever they did, which we don't control, but it's still more likely than not that it was suicide. And that's all Dr. Reich is saying.
As to agency, and again, on Rule 75, so what is OMI characterized if they're not a state agency that could potentially be governed? There's no procedure, you're telling us there's no review. That's kind of the idea of 75. Why don't they fit into that category of a state agency?
I think, when I say 75, it could apply. What I'm talking about is the very narrow fact that is before this court, which is the pathologist's determination as to manner of death. So when I say, I don't mean to say that this agency gets to run wild and there's no review. Certainly 75 would apply. I'm only talking into this very limited point of a pathologist's opinion as to manner of death. Because I'll give you an example as I was just up here thinking. If
What
I'm
if-
oh, go ahead.
Sorry, what if it was an error in cause of death?
If it was an error in cause of death,
Mm-hmm.
so again,
Would Rule 75 be available then? Or, because cause of death is treated somewhat differently than manner of death.
it is because manner of death, for example, is not admissible, where cause of death potentially is. Whether or not you could do a Rule 75 against a pathologist's determination of cause of death, it was an interesting question, just because it has a little more prima facie value than manner of death. I would still say that probably the most important thing to do is to look for the legislative intent, which is to try and minimize all of these different trials by individuals who don't like the opinion of the medical investigator. And typically with cause of death, I'm thinking in the terms of a criminal trial, and the person who would be aggrieved by that would be the defendant. And that person has a legal remedy within the criminal trial itself to challenge the cause of death,
Much like a civil proceeding.
just like a civil
As
proceeding.
opposed to changing, I mean, you have death certificates that may say it's murder. Jury may disagree, we don't change the death.
We don't change the death because that was the opinion of the pathologist. And what I would say is this is one of the things as my time runs out, we need to be careful. There are wide public policy problems here. If you allow, whether mandamus or a writ, if I'm a criminal defendant, this is what I'm gonna do. I'm gonna challenge the homicide determination in a civil proceeding. And then I'm gonna go ahead and also have my criminal proceeding. And if I'm successful before a judge in changing it into civil proceeding, then I'm going to try to bring that back that door into the criminal proceeding. In essence, I'm going to get 2 bites at the apple. And that's one of the things that we have to understand is that the legislature wanted to try to minimize all of these coroner disputes where we used to bring everybody in, everybody testifies, we put up what the doctors say, and ultimately a coroner or someone comes to this conclusion.
Someone elected.
An elected official. Texas does that.
Mhm.
I'm not sure that we're one of the most modern states when it comes to death investigations, and we want to keep it that way. And I ask that when this court makes this decision, truly think about the public policy ramifications of allowing an estate, an individual, to all of a sudden have standing to start challenging manner of death. And I have 33 seconds, so I'm happy to take
Any
one
other-
last question.
Question.
Thank you.
Thank you all for your time.
Ms. Garrity.
Thank you, your honors.
And I'm gonna pick up where Justice Bacon started. What's the injury to the estate? The personal representative of the estate of Mary Hahn brought this action. Where's the injury to the estate?
The injury to the estate is not having an accurate record of their loved person's death.
To what end, though? I mean, when we're talking about injury in fact.
Yes,
To
the
what
injury,
end?
it's really an emotional injury. It's an emotional injury that this death scene,
The estate doesn't have, as Mr. Melender says, and it feels a little callous to say it out loud, but the estate is not a person. The estate doesn't have feelings and emotions. And I think that's an important point. The estate is not, if I am the personal representative, not win, not if, when I am the personal representative for my father, my role as personal representative is a distinct legal entity from the estate. The estate is not the human beings and therefore cannot suffer mental anguish. Only people can suffer mental anguish. And I am sure there was plenty of that here. But the estate is no different than a corporation in that regard.
Yes, but it seems to me that the construct that you're presenting ignores that the estate is actually represented by the personal representative.
But they're distinct under law. I mean, it's black letter law. The estate is a distinct legal entity. Ergo, it's not human. And so I can't conceive of writing an opinion here that says that an estate, as a legal construct, can suffer emotional injury that is compensable in some fashion. That would turn our law upside down.
We're not seeking financial compensation, but there
But they
still
can't
is
suffer that
injury in
injury.
fact. Financial injury isn't the only kind of injury
No, but even
people can
emotional
suffer.
injury, an estate is a legal fiction. It cannot suffer emotional injury. So I think you need to find a different hook
Well, it is.
than that.
Well, we do think it is a matter of public interest, what has happened here, and the failure to follow rules and regulations that we believe are mandated.
So you want us to use the great public importance doctrine to grant standing to the estate. Is that a fair statement?
That would be a fair statement, and I think that that is allowable
But
under
our
our case law.
law just doesn't, I mean, I've read numerous cases, Ms. Garrity, about what great public importance means. And it's not this kind of injury. It's separation of powers.
Well, Your Honor, I mean, with all due respect, I think that when you read the Cornea cases and the cases out of Pennsylvania,
I'm talking about New Mexico case law on great public importance. Our case law does not go down this path. It is limited to clear threats to the essential nature of state government guaranteed under the Constitution, such as separation of powers. This is not this does not rise to the level of a separation of powers problem.
well, Your Honor, I would point to the language in City of Albuquerque versus AFSCME, where it says mandamus affords proper remedy to compel public body to act. When an inferior tribunal, corporation, board, or
That's
person.
different than standing. We're talking about standing and great public importance, not mandamus. You can't, mandamus law does not ergo provide you with standing.
Well,
You have
under-
to have individual standing.
This court has recognized under the great public interest doctrine, the public interest in navigable waters and being able to fish in a river and
Because
not
there's a
trespass.
constitutional right. Here, there is no constitutional right to control, that would control the opinion found in a death certificate.
We are asking you to create an interest using due process principles in this family to bring this mandamus action in great public interest, and not simply to rely on the fact that only the New Mexico Attorney General could bring this action. And that ignores the fact that theoretically, under the scope and duties of the New Mexico Attorney General, they're supposed to be representing the state entity. And clearly, they're not representing the state entity, and even though they directed OMI to change the death
The
certificate.
Attorney General hires outside counsel regularly to represent state entities, so.
Well, but still, Your Honor, I mean, if you're going to read the technical statute says that the Attorney General is supposed to do that. So my point simply is that, you know, when you look at this case, we do believe that they're standing. Who else would bring this case other than an estate? If you think about it, who else would be injured? And to piggyback on the fact that there's absolutely nothing available to families to contest anything, that would ignore
Let's
the
assume
language.
for a moment that the manner of death is ruled to be an accident. The family says, no, my family member would not have that kind of an accident. We want it to be changed to undetermined because it causes great anguish to the family to think that Grandpa Mike V. Hill would have an accident to cause his death. Standing?
No, because there's no underlying facts that there are any violations of the duties.
Same facts.
Same facts, then I do believe that there would be standing. Because the family is the one that's injured. I mean, that the family, legally, the form that takes is through an estate. But you can't ignore the fact that, I mean, under the law, technically, Madam Chief Justice is right. An estate technically doesn't have feelings. However, I think that that really does ignore, the legal construct really ignores what's actually happening and going on. And just briefly, if I may,
I occupied lots of your time.
There's no record of that the decedent was intoxicated. There was alcohol in their system, but it was below the BAC, and that there was no evidence of over-medication.
But the basis for the district court issuing the writ is based on facts that were unknown, that were not considered.
Correct, and the point is that there was not a medical legal investigation undertaken here that conforms to what the legal requirements were for OMI. When you strip it all away, that's basically what happened here. They didn't do what they were supposed to do under their own regulations. And they don't provide a process, even though in state law 241117, there is an inquest process in our state. Now, maybe that takes us back to a golden era that OMI doesn't want to return to. But the point is that if that's the case, then they should change the statute. Because the statute does provide some kind of form of an inquest. There shall be an inquest. And so the argument is basically we're being foreclosed from all avenues of relief when there was a terrible injustice that was committed here. And the injustice was not really following the rules. And if anything that we have to rely on public officials to do is to follow their own policies and procedures and rules, because that's how we come up with rational, just results that are not arbitrary and capricious.
Sovereign immunity causes a lot of injustice, but it's the law.
That would be true, but the king is no longer sovereign in our state, thankfully.
Except
But
sometimes it is.
I don't think that there's been
Well,
OMI
regardless,
is
I mean,
judicial
the
immunity.
point, you get the point.
Yeah, I do. Your Honors, thank you for your time today. We really appreciate it. And on behalf of the family, we thank you greatly for accepting this case.
Thank you, counsel, for your presentations today and for enduring a lot of questions, which I know it can be tough. The case is deemed submitted as of today. We will get a decision to you as soon as practicable. And with that, we'll be in recess.
Report, please.